Awesome. Thank you so much, Allison. I just want to start by thanking Allison and Boyd for putting on this special needs planning session for us today. I think we're all really excited to learn more about guardianship. I'm Lauren Abel. I'm the founder and the executive director of the Next Step Academy, and we serve mostly individuals with autism spectrum disorders, but also other kinds of special needs in the Spring Branch area. We have a day treatment center and also a day school, and then we offer supplemental services and support to parents. So we're excited to partner with you guys. And if you want to learn more about the Next Step Academy, you can visit our website. It is thenextstepacademy.org. So thank you so much, Allison and Boyd, and I'll hand it back over to you.
Thanks, Lauren. Thanks, Ben. Thank you for having us. Allison Scobber, Consolidated Planning Group. Thanks for joining us today. If you're new to us, welcome. We're glad you're here. Today's meeting is being recorded. Your cameras and your microphones are muted, so we can't see or hear you. But we want to hear your questions. So the chat box is open. And so as we're going through the presentation today, if you have questions, we invite you to put them in the chat box. This recording we will send this recording out either later today or tomorrow, so you'll be able to reference back to this. I am excited to be back with Boyd Handley from the Handley Law Office. Consolidated Planning Group, we're a special needs planning firm, and we're always, week after week, day after day, we come across families that need legal services when it comes to special needs. And a lot of times people really don't even know, why do I need a special needs planner? Myself, Consolidated Planning Group, why do I need a special needs attorney? Boyd Handley, the Handley Law Office. And I always like to say that, when it comes to special needs planning, we're the money and he's the paper, the legal documents. So when it comes to this, there's a lot of things that we have to do to do the right way. And that's where you're going to need the attorney. So the attorney doesn't do the financial side. I don't do the legal side, but we work very closely together. So today what we're talking about is guardianship and alternatives to guardianship. And this is truly, Boyd, this is a hot topic. It never ends on what comes up with this. And it's something that what we find is it's a little overwhelming to a lot of families when we start thinking about guardianship. So having said that, I'm going to just turn everything right on over to Boyd, and I'm going to let you take it away as we go deep and wide into guardianship.
Well, thank you everyone for being with us today. I'm an attorney in the Katy, Houston area. I've been in the same shoes as you have. I've got a daughter with special needs who's, my goodness, 27 now. We went through guardianship with her. Back when we were doing guardianship, it was in the courts, so we had to go downtown to the court. We were in Harris County at that time, and now we're doing everything by Zoom. But it's still a very traumatic and emotional time for parents. I know with us, we knew our daughter was going to have guardianship, but until she turned 18, we thought about it, but then it almost hit us in the face with a baseball bat. Very emotional, very hard to go in and take rights away from your child or young adult. And so, what I want to talk about today is trying to give you what guardianship's about, what the alternatives to guardianship are available, and, just how to make yourself feel better about making that decision, whichever way it may go. Unfortunately, I have to give you a disclaimer. This is not an attorney-client relationship being formed today, and all this information is general information. I've had other parents come in and say, well, Mr. Handley said this to their attorney. Well, each person's situation is different. So take all these facts as general information. And then if you have another attorney, then talk to that attorney and say, well, we heard this, what about this? I'm not telling you this is exactly the way it works, but hopefully this information will help. Next slide. In my practice, I have what we call a special needs toolkit that I try to put everything together and talk to my clients about what's needed. And a lot of this has been what we did for my daughter as she was growing up. But today we're going to talk about the left-hand side, the guardianship, what it is, do I need it, and then what are the alternatives to guardianship. Next slide. Here's just another way of looking at all this. With the alternatives to guardianship, we're going to talk about what's a power of attorney, what's a medical power of attorney, and what a HIPAA agreement is, along with decision-making agreements. Next slide. Okay, why do we need guardianship? Well, unfortunately, in Texas, when a child turns 18, he or she's an adult, whether she's mentally ready or able to be an adult in the real world. And in order for us to continue what we were doing when they were age 17, we have to either put some legal documents together or get guardianship of our loved ones that have disabilities. Next slide. When a parent comes into my office or gives me a call and says, well, I think I need guardianship for my daughter or son, I look at this list of things that's put out by the American Bar Association, and always say, okay, do they really need it? And we start asking the questions and looking at the information. And, you know, sometimes it's very apparent that a person needs guardianship. And then a lot of times it's on the line, you know, do we need it? Why do we need it? And what are the risks involved with not getting guardianship? And I try to talk to the parents that come to me and go through everything prior to making a determination. Next slide. Had a lot of reform with guardianship in Texas in 2015. A lot of this had to do with different situations in other parts of the country where a disabled young adult might have been taken advantage of by putting them in guardianship when alternatives could have worked. And then a lot about, you know, as elderly people get dementia or don't have families, and you don't have the power of attorney and medical power of attorney in Texas. Like my parents, they were very good with me. They gave me the medical power of attorney and power of attorney to look after them. But if they had not done that and had not and had gotten incapacitated, whether dementia or whatever, the only thing that you can do in Texas for your parents is to get guardianship. And that's just not necessary when there's other alternatives. And, you know, that's why we like to get out and talk to families about this. With the 2015 work that was done in, they passed the Alternatives to Guardianship, which requires the attorneys in Texas to go over that with the families. And then they came up with a supported decision-making agreement, and we'll go over that later and tell you what you can and cannot do with that. Next slide. Guardianship in Texas, there's 4 different kinds. There's guardianship for the person. That can be full and limited. That's usually what happens with when our kids turn 18. What that means is they really don't have any assets, so you really getting guardianship of the individual itself. Guardianship of the estate is mostly with elderly people or older individual that may have been in a catastrophic accident and now is incapacitated because they have homes and bank accounts and things of that nature. Guardianship of the estate is very complicated. You have to actually have to give a report to the court each year, and a lot of filing involved with that. What I mean by full and limited, there's about 15 different rights that are taken away in a full guardianship, and in a limited guardianship, we can pick and choose. I have a lot of clients that have guardianship, but they allow the individual to still vote in a public election. So that's what I mean by full and limited. And you can have guardianship of the person and the estate at the same time. Temporary guardianships, if you might have someone in hospital that's incapacitated but not permanently, you may need a temporary guardianship with that. I had a situation where a family in their will had named someone out of the country as guardian. of their loved one, and it may be where they have issues getting into the country with a visa, and you can get a temporary guardianship for a family member or a friend until that guardian named in the will gets into the country. Next slide. I always like to tell parents guardianship is not permanent. And, you know, a lot of times our kids may not be ready at age 18, but, you know, as they mature up in maybe 4 or 5 years, they could be ready to get a lot of the rights back. And you can always go back to the court and petition the judge to give particular rights back. I always like to tell this, of course, you can read it, but I enjoy telling it. A couple of years ago, when the courts had a lot of changeover, I started going to visit the different judges to see how they would run their court. And there was this one man sitting next to the bench to me, waiting on the hearing to start, and was asking me questions with his machine. He was nonverbal. So I was talking to him, kind of got a kick out of that. And lo and behold, he was had a court hearing and was given his guardianship was given back to him. He had gone to HCC and got a computer science degree, and even though it's nonverbal, it was happening. So it was actually very teary-eyed in court. That's the first time I've been associated with that, and it was just a great feeling, and everyone was clapping in court and everything. So I always like to tell that story to parents, is that, you know, this is not a permanent situation if it's not needed. Next slide. Here are all the guardianship rights. I won't go through all of them, but the first 5 in bold are the main rights that are taken away. Public election, of course, you can pick and choose that. I've got, as I mentioned, a lot of clients with that, but operating a motor vehicle, ability to purchase firearms in Texas, you have to have that. Making personal decisions regarding residence. I always like to tell parents, go ahead and put that in the rights being taken away, because what I like to say is guardianship, an individual under guardianship still has their rights. They can actually go off and live with someone else, even though you have the right to pick their residence if they're not in immediate danger. They can do a few other things as long as they're not in immediate danger. So you have to realize that even though you have guardianship, it's not one of those where you've tied the individual down and they have different rights.
Can you say that again? Because I need clarity. So yeah. You're saying, like, even if you have guardianship of the loved one, they could run off and go live somewhere else?
That's correct. You know, you can pick where their domicile is, but if they're not in any immediate danger, then the police will not go take them from that location. So
just for it being oppositional, as long as they're not in a dangerous situation, the police won't intervene, even with guardianship, is what you're saying?
That's correct. And but you know, I think it's probably fairly open. I mean, you can come up with some excuse why they are in danger, but individuals have rights, and so you just need to be cognizant of that. There is a whole 2 or 3 page worth of information in the Texas Code, which we actually give to clients, of the rights of the ward. The ward is what we call a person under guardianship. Terrible name, but that's what we call them. But they have their individual rights. And even though we take these away from them, they do have rights in a lot of cases. Yeah, the guardianship of the person, that's what I do mostly with, that's what we have on my daughter. That's what I do mostly with kids turning 18. It's fairly simple process to go in court. You do have to have a physician certificate signed, which is signed by MD or physician or psychiatrist. And what that basically does is show the court how the disability affects the young person's everyday life. And I actually talk to parents and ask them to, if they're on the borderline on whether guardianship is needed, to fill that out. And that will give them a good idea about what's going on. Next slide. Guardianship of the state, in most cases with our situation, that would only be with an elderly person, and that deals with the financial assets of the person under guardianship. And in all fairness, when you are doing guardianships, you can file, regardless of whether it's personal or the estate, 180 days prior to the individual turning 18 for a young person, and then anytime, of course, with a elderly person. And then if there is an intellectual disability involved with that guardianship, if you have a report that's been done within the past 2 years, then that can be used when you're filing for guardianship. But I normally tell parents to give me a call 8 months ahead of time, because with the COVID situation, you may have a hard time getting a doctor's appointment to fill out the physician certificate. Next slide. As I mentioned, 180 days we can file prior to them turning 18, and you can do it after they turn 18. The main difference is when a person has already turned 18 prior to filing, is that they really look at the alternatives to guardianship and whether that's viable. If your child is already 18 and above, if they have a intellectual disability and their score is a certain score, then it's really automatically that alternatives will not work. But we always look at all of that. I think the one thing that's kind of scary, of course, my daughter enjoyed it when the constable knocked on our door, but once you file, about a week to 2 weeks later, depending on what county you're in, you'll have a constable knock on your door and ask for your loved one to be served with the guardianship application. That can be kind of unnerving with you. With my daughter, she loved it, but with some, it's very hard. In most cases, your child doesn't really need to be there because, unfortunately, they won't call you ahead of time. But a lot of cases, they'll just serve the parents that's there. The other thing that goes on with guardianship is that we register you with the JBCC, which is the judicial branch in Austin that covers the guardianship process. And you have to do a 30-minute to 45-minute PowerPoint presentation and look at that. And you get a certificate that we file. When I did it, a number of years ago, I took it again because when I did it with my daughter 8 or 9 years ago, they didn't have this, and so I took it just so I could tell my clients what to do. But at the very beginning, we were actually answering questions, and from what I gather now from my clients, you just have to listen to the whole presentation, so there's no test involved. With all the courts, you're going to be appointed an attorney ad litem to look after your child's interest in court. In Harris and Montgomery County, those are what we call the statutory probate court. And they actually have a court investigator that is assigned to your child or your case to ask questions for the judge ahead of time. And so that person will be calling you up, talk with you and your husband if you're all co-guardians, along with your child that's turning 18. The only other thing, if you've got if your child has adult siblings, we would send them a waiver notice agreeing with mom and dad being the guardian. If you've been through a divorce, have remarried and have a step parent that wants to be guardian with you, then that's possible if the biological parent signs a waiver agreeing to that. So the only time you can have co-guardianship is with biological parents or with a biological parent and a step parent if the other biological parent agrees to that. And if the other biological parent is deceased, then there's no problem with that. About the only problem that you have with a guardian is be sure you don't have a criminal record. I've had a number of parents that have had criminal records 20 and 30 years ago when they were younger. Recently, I had the court agree to let them have guardianship because that changed their lives around. It was a drug charge and living, and we actually had letters that we sent to the court along with a letter from me and the parent, and the judge agreed to that. On the flip side, we've had a case that I was an attorney ad litem on, that one of the parents had a DWI 2 years prior, and the judge would not allow that parent to be guardian. And the judge actually told the parent, come back in 2 years. If you haven't had a DWI in 2 years, then I will consider it. So I give we've got great judges in all the counties. At the end of the day, they look after the children and what's in the best interest of the children. So I've been extremely pleased with how the judges in my cases have treated the parents and everyone. So I have nothing but high praise for all the surrounding probate judges. Next slide.
Boyd, can you answer just a few questions? I guess I would like you to talk about that, the certain IQ range that you're referring to. I want you to kind of, for families that don't know, they're exploring this. There are some things, and I hate to use the word slam dunk, right? Like it's just crystal clear that guardianship is needed. But we see a lot of families that it might be needed right now. It might not be needed in the future. Maybe the IQ isn't below that magic number. So can you talk about the slam dunk and the ones that are on the line?
Sure. I've had individuals with IQs of 125 under guardianship due to mental issues. Social Security has a number of 70 as the above and below. Past couple of years, they have changed that, where even if it's 70 or below, then you have to have other things that or a disability in order to get the guardianship. I know 9 or 10 years ago, it's a slam dunk. If you actually have a particular number, maybe 60 or definitely in the 50s, but I think that's changed from a alternative to guardianship, such as power of attorney, medical power of attorney. In my practice, I have a cutoff at 70. If your IQ is 70 or below, then I will not sign a power of attorney for your child or young adult. I understand that number since I've got a daughter with special needs with intellectual disability. I know there are some firms in town that will sign one at 70 or at 65, but I won't. And I'll explain why that more when we come to the power of attorney and medical power of attorney. But you have to realize that at some point, even though your child tests low, they may know a lot. And it may just be due to that disability where they don't test very well. I know with my daughter, she doesn't test well, but she can go into a computer and execute an executable and do a program. So it's there somewhere, but we know our children better than anybody, and it just really depends. So I didn't answer your question, but at 70 is my cutoff. You may get to 65 with some other attorneys, but below that, then it's really questionable whether the young person understands what he or she is signing. I mentioned the JBCC course. This is just the first page of the course. I took it just so I could tell parents what's going on with it. I was actually grandfathered because my guardianship came in prior to 2015, but I decided to go ahead and register my guardianship anyway, just to take the test. But it's really good. After being a guardian for so many years, it gives you a good idea to be an online course on what you should expect, some of the questions you should be asking yourself. So even though it's required, I highly recommend it, and for anyone doing guardianship.
So is this a free course, or do you pay for it? And so you said the JBCC training course, they could just put that in their browser and they could find it?
Yeah, they can put it in the browser. You have to register for it. I've had parents that have taken it before they file for guardianship. I don't recommend that. What I do in my practice is I register you with JBCC and also register you for this course. It's required. We have to have the certificate filed with the court in order to proceed with guardianship. It's just very good and required, no charge whatsoever on it. Next slide. I mentioned the physician certificate. I know you can't see this or read it, but maybe you can. I could. What this is the first 2 pages, and what this does, especially on the second page, is it goes over the issues with your child and their disability on how it affects their everyday life, and it's excellent for a parent that may be on the line on whether guardianship or alternatives to guardianship is needed. On the first page, of course, it has what are the disabilities itself. We name them. Second and third pages, you have the daily issues that are involved. On the fourth page, third page, which I don't have here, is that there is a whole portion of the page on intellectual disability, where the physician can put in the number score on the total IQ. And also a lot of times we have physicians that are filling out this certificate, and they're usually not the ones that do the intellectual disability test. So we can use a school test, we can use a psychologist test, and if you have a psychiatrist that's done it, of course, they're the MD, and they can put in. But we do have a box here on that intellectual disability where the physician can say that they're using someone else's test as long as it's within a 2-year period of filing. So that gives your physician the ability to mention your intellectual disability, your child, on the report for the judge, and then not have the liability since he or she did not do that. Who qualifies for a guardian? It can be almost anyone, a family member or a friend. The ward's parents, the ward is what term we have to use. It can be family members and grandparents. What I tell parents to do in their wills, if they have a will, then we can do an addendum to it, a codicil, or just a sheet that names the guardian of your child, because that's extremely important if you and your spouse die in an accident and you have guardianship of your child. It's also very important if you have minor children to have who you want to become guardian of your minor children. If you die in a wreck without a will, you have minor children, or you have a guardianship of a loved one, then the state of Texas will determine who's the best person to be. They'll first look at grandparents, then they'll look at siblings, and they'll go down the heritage line. We've had, a lot of families have wonderful parents, but some of the grandparents are better than others is taking care of their disabled child. So it's very important to have that. The way that works in court is that if a family member, if you and your husband or a single spouse that has guardianship dies, and they have in their will who the alternative guardian will be, whether it's for a minor sibling without a disability or from an older child with guardianship, is if you name that person in your will, then the person named would, of course, hire an attorney, go to probate court, and they would have your will, your death certificate. Of course, we have to get the physician's certificate signed, but in most cases, I've done a couple of those, and the judge does not have any problem in appointing that person as to be the guardian. So it works very well, but you need to have that in your wills. As long as, we've talked about a criminal history, you have to be over the age of 18 to be a guardian, and you cannot be indebted to the guardian. That has a lot to do with older people that their kids or someone may want guardianship, or a family member or a friend. But if you owe money to that person, then the court will really look at that and try to determine if you're trying to take advantage of them or not with that. And being a guardian, we have to file an annual report each year with the court. You also get guardianship letters. They're kind of confusing because they're good for 16 months, although you have to file your annual report every 12 months. So there's a disconnect with that. Why the courts did that, I'm not sure. How you get to 16 months on your guardianship letters is that you have, of course, 12 months for the annual. The courts give you an additional 2 months to get your act together and file the report. I normally tell parents to send that into the county by certified mail, especially in Harris County. It costs $12 to file the report in order to get it in. And then once you file the report, if you don't do it at the same time, we do ours at the same time, even though we're losing 2 months each year, it's just a lot easier. But then 2 months later, you need to file to request new guardianship letters and before the 14 months is up. And then, of course, the judge gives him or her another 2 months to sign it. So you have to have the report in before you order your guardianship letters. So it's just a very disconnect, which parents can actually forget about. I try to tell my folks every year what to do with that. Next slide. Alternatives to guardianship. I've got one story I like to tell before we get into this, is that you may have a very high functioning child. And I've got a number of clients who have adopted individuals, young kids, and then as they grow up, they have what they have found out to be alcohol syndrome. And what that is that during gestation, the mother was drinking, and actually part of the brain is missing. These kids are normal, I can have high IQ, but they have anger issues. And I tell my parents is that if your child has that, think about that once before they turn 18, and whether alternatives to guardianship is something that you can live with, or something that due to anger issues won't work. Because once these kids or adults, when they turn 18, signs a power of attorney and medical power of attorney, and they have mental or anger issues, all they have to do is wake up one morning and be mad at mom and dad and say, if they say it to the right people, well, you're not my attorney, you're not my agent anymore. And that legal document, which you've had notarized and signed, power of attorney and medical power of attorney, can go away overnight if they say that to the right person. So I always tell parents to be, although alternatives to guardianship is great, and I promote those, be aware of your individual child situation and whether these will work due to mental issues or fetal alcohol syndrome.
Also, Boyd, this is where I like to say for those of you that have neurotypical kids, this durable power of attorney and medical power of attorney is a real good idea when you're sending your 18-year-old off to college. You know, anything can happen, and it's an important document to have if there was an accident, they were hospitalized or something like that. And a lot of times we don't think about it. We're so busy thinking about our kids that need special care. But this is something that's important, and you hit on this earlier with our aging parents. It is truly important to have this conversation with your aging parents or aging loved ones that you're actively involved in their care and stuff. You want to make sure that these documents are in place before it's a day late and a dollar short, before somebody's had a stroke. So think about, do you have these documents in place? Do your parents have them? And do you need this for your 18-year-old older child that's in college? I think those are all good things to have on your list.
Yeah, I like to add to that is that, a lot of our parents were not as good as mine. They don't want you in their business. And so we can make these power of attorneys and medical power of attorney only active when the person loses income capacity. And we can have a doctor sign that proving that the person is incapacitated, and we can actually have two doctors. So if you're talking to your parents, tell them that, you know, we're not getting in your business, and we can put all those stop goats in it in order before we do take over and help you. With your kids that are going to college, it's either one. I normally tell parents if their kids will let them do it automatically, that's great. We've had one situation, I go back to the fecal alcohol syndrome, where a young lady who was over the age of 18 ran away from home. She was put into one of these mental facilities, and mom and dad couldn't find her for 2 weeks. First, they didn't have the medical power of attorney or power of attorney signed, and she was over the age of 18. So these hospitals won't talk to you if you don't have this. So it's very important. Another situation, my wife's mother was in an accident a couple of months ago, and she was taken to the hospital, groggy and all of that. And if my wife had not had the medical power of attorney in her phone where she could send it to the doctor, she couldn't check on her mom. She was doing it, it was the height of COVID, and she was doing it from the parking lot. So extremely important to have this on you and your spouse too. Nowadays, it's almost better than a will with that.
One thing, Boyd, I was seeing your number 8 here on the screen, the representative payee, is that as it relates to the Social Security Administration. And one thing I just wanted to mention is the Social Security Administration has their own forms for you to be able to talk on behalf of your child. So even though you may have power of attorney, you may have guardianship or limited guardianship or supported decision making or any of those other, all those documents that you would think would be sufficient, that is not how it works with the Social Security Administration. So I just wanted to share that with you. There are very specific forms to become a representative payee. There's a 3288 form if you have a child that's an adult child that's getting SSI and you want to be able to help that child, but you're not the representative payee. But all of these documents, they're good for everything else, but not them.
Yep, that's correct. That's correct. All right, we're going to talk about the ones in red here, and I'll tell you some of the differences between all three of them. And next slide. Power of attorney, medical power of attorney. I've mentioned before, you have to have mental capacity to understand what you're signing. They've got a lot of legalese wording in it. They've got risk involved in it by the person that's signing it. So you're a young one, or it's just turned 18. You think he or she doesn't need guardianship, but they need to understand what they're signing. As mentioned, 70 is a cutoff in my practice, just due to liability issues with me and understanding what that 70 means. And also, if something happens and you as the parent have gotten your disabled child to sign one, and you may do something that someone else feels that is not reasonable, then you need to be careful. There's liability of you being agent for your disabled person if they don't understand what they're signing. And these two documents, you have a fiduciary responsibility to that person to do everything correctly without a lot of risk involved to the benefit of that person. So you have a legal responsibility to take care of them. There we go. What I will say while we're getting back on track is the decision-making agreement. I had mentioned that came out in 2015, along with the deal with really looking at the alternatives to guardianship. And this is a very good document. I don't have them in my practice. I refer clients to the internet. We have the ARC of Katie, the ARC of Texas, that have very good disability rights, has a very good form that they use, but it has some limitations. It's not a fiduciary form. You don't have any legal right to do what you're supposed to with the person you're helping out. It has a confidentiality part to it. Basically, what that means is that if you're getting information from the doctor or providing information to people, you have to keep everything under a confidentiality type situation. And also what this document does, you can go to the next slide. It allows the parent to sit in on meetings to help explain to their individual with disability what the meeting is about. And the good thing about this document is that the legislature, whether it was on purpose or not, did not specify the level of capacity that the individual has to have for signing the documents. The way I read that is that they can probably sign it as long as they have an idea of what it's about. I don't think they need to really understand what they're signing, and in many cases, they probably can't. But you won't be held to the higher standard that you do in a power of attorney, a medical power of attorney signing. And this is also good. You may have families that aren't quite ready to do guardianship. This is their only thing to do. And you may have people that do not have the financial capability of doing guardianship at the time, although there are some areas in firms in town that do it pro bono. We can petition the court to pay a lot of the fees for underprivileged people, but this is something that you can use in the meantime. It will allow you to sit in with the doctors. I haven't heard where the doctors did not allow you to, but they possibly could. The ARG meetings for sure allow you to sit in on those. So this is a good escape. This is a good in-between document between alternatives that they may not be capable of and guardianship, which you may not be ready to do. Next slide.
Boyd, someone asked, if you have a supported decision-making, couldn't you explain to your loved one the impact and what they were signing of a power of attorney? Is that a way around that or not really?
No, they have to understand what they're signing. I mean, when I'm in a meeting, I've done 2 or 3 with children turning 18, and I'll get the parents out of the room. I've got to have the young person in the room with me, and I'll ask tough questions, because if you have the parent in the room, they're going to look to the left and to the right and say, "Mom, is that right?" And that's not going to give me the ability to understand whether they know what they're signing. So that's why I tell parents is those are very important and documents, and be careful if you have your loved ones signing those if they're not understanding it. Next slide.
So can we just stay on this for just a second longer? So if in the event, I guess this is the question of the slam dunk or walking the line again, is if in the event we have a person that's IQ is 70 or below, so they don't understand, they don't have the capacity to understand, and it's not your decision. I mean, this is in line with what Social Security says. I mean, this isn't an arbitrary number, so they can't really sign a power of attorney. But the supported decision making really, I mean, it gives a parent a right to talk to their kids and talk through some of these things, but ultimately the child still has the ability to make the decision. So if in the example, I mean, so is this the slam dunk? So if in the example they cannot sign a power of attorney, their only document available is the supported decision-making agreement, then this makes them truly a candidate for guardianship or limited guardianship. Is that a fair thing to say?
Well, I would say that if they do not have the capacity to sign a power of attorney, a medical power of attorney, then if you don't get guardianship, then they're like an elderly person. Someone could come up and say, "I want to sell you a car for $1," and they'll sign a car contract, but in reality, they're signing for thousands of dollars, or or they're at the doctor and the doctor says, well, you need to have this operation or you're going to die, and the child may not want a needle stick in the arm. So without the medical power of attorney, mom and dad can't well, you can't force them anyway, but mom and dad can't make that decision with the doctor. Well, you need to do this life or death. It's not that they're going, emergency where the doctors have to take care of you, but if there's a selective type procedure that could either cripple if you don't get it, or maybe death in the years to come, then if you don't have guardianship or the medical power of attorney, that young person, it will make the decision for themselves. And the whole thing of this is that we're trying to protect our loved ones. So we really need to be sure that they have the mental capacity to make life-changing decisions. And I think that's the main goal is, are they able to do that? With the supported decision-making agreements, you can explain, if you could go to the next slide. You can only explain what's going on. You can assist them in making a decision, and assisting meaning, here's the documents that I can read to you. And a lot of times you can explain to your loved one better than a doctor or a professional can. So you're there explaining what's going on with your child or young adult, but at the end of the day, he or she has to mark on the dotted line. You cannot tell the doctor he wants to do this. That person has to make that decision. So I think that's what a lot of confusion on the supported making decision agreement is, that it's supported. It's not a decision. It's supporting the individual with his disability for him or her to make a decision. And I think that's what I'm, trying to get out to everyone.
So I think there's been some confusion, and I know that Texas is like one of very few, or like that even have a supported decision making, not
We're
agreement.
one of the first ones in the country.
Right. But I guess what my question is as a parent, so is this just the document that gives me the right to be in the ARD meeting? Because as a parent, aren't we already helping our kids? Aren't we already supporting their, decision-making process? So do we need a document for what we already have, like as a parent, or this just gives us the right to sit in these meetings?
Gives you the right to sit in on meetings. Of course, once these kids turn 18, they can tell the ARD that they don't want you in the meeting. And sometimes they're not able to tell the ARD that you need to be in the meeting. So, this is just something that helps parents get in the front door when normally they cannot without a power of attorney, medical power of attorney. I haven't heard any negative things from this agreement, but I haven't heard any really positive things that, parents saying, well, this worked here. I haven't heard any of those. So I think by not hearing anything, it's probably working. I haven't had any parents say that it didn't work for them.
Okay, so that was a question too. Is this document like widely recognized by healthcare schools, other formal entities?
Well,
do they all understand?
It's actually in the code. So, it's whether they recognize it or not, you can say that, well, this is a semi-legal document from the situation that the legislature has in the state code. So, it has a lot of bearing. It has a lot of weight. It's like we have a statutory power of attorney, which is in the code. And the banks can come up and say, well, we're not going to, before 2015 or so, I think it was 2017 on that, but the banks could say, we want you to use our power of attorney. Well, they can't do that anymore, but they can keep you about 2 weeks from doing what you need to do with the statutory. So it's almost with the decision-making agreements, it's in the code, and they really have to abide by it.
And I do think that the schools, and my experience, not with my own kids, but with the families that we work with, that the schools are definitely an understanding of this. And this is an important document to have. Again, if your student is staying in the school system beyond 18, this is important to be able to navigate some of that, some of their education decisions and things like that.
I've actually had parents that have told me the school required their child to sign a power of attorney for them to sit in on the ARG meetings. And I just kind of shake my head because first we were in the process of getting guardianship for the child. So we knew the child was incapacitated. So, and so really with the child signing that power of attorney, although it was before we had the hearing, it was really a worthless document with that. But at the end of the day, we try to do whatever we can for our kids, and there's a supported decision-making agreement is a very good document to help parents out, either in between getting guardianship or if they're not going to go with guardianship. We've talked about this. Of course, I mentioned when your child turns 18, he's an adult, he or she, you can't do what you did prior to 18. And so, you've got to have some documents in line. We've already talked about your parents. Please get those documents. So power of attorney, medical power of attorney. We haven't talked about HIPAA, but that's a document that you need in order to call the doctor and get medical records on your loved one. That's important also, but please get those 3 documents on your parents. Very important. And as Allison mentioned, your kids going off to college. I will say that as a parent with a kid, a daughter with special needs, an adult now, support groups, going to these seminars, and taking care of yourself. I mean, I know my wife doesn't take care of herself on trip. She needs some time to herself. And I always tell parents is that we have to look after ourselves. If we get ill, then who's going to take care of our child with special needs? So please look after yourself also, because that's very important with eventually keeping tabs on your child.
Couldn't agree more. Boyd, we have, and I know we're coming around the bend on time. One person said, I'm still not quite understanding partial guardianship. Can you petition the court only to have guardianship over certain rights, like medical and financial,
That's
but
correct.
leave other rights off, like marriage, residence, and driving?
Yeah, that's correct. I've got one where we were allowed voting and driving. I don't, the child had a driver's license. I'm not sure I would have let that person drive due to liability issues, but that's happened with me. You can pick and choose. What you have to be careful is that you need to talk to your physician who's signing the physician directive certificate. What you cannot have is that the physician says that the child should not be able to marry, make decisions on where they live and things of that nature, or drive. That's one of the questions. And it's very difficult, if almost impossible. I've done it with the voting, where the physician certificate said the child could not vote, but then we argued with the judge. But marriage and driving a car, if the physician certificate says the individual is not capable of doing that or making that decision, then the judge will definitely not give you that. That's happened a couple of times to me. So when you're doing partial guardianship, just be sure before the physician certificate signs that document that y'all are in agreement with what should be taken away and what should be left with the individual.
Okay. Can you tell us what you use the letters of guardianship for, please?
Okay. Talking to a doctor. With my daughter, we had a situation of the day where I took her to a doctor's appointment and they said, well, Mr. Handley, you can't come in. I said, yes, I can. Here's my guardianship letter. And, with someone that's incapacitated, they can't make decisions legally. So you have to be with them. And in my situation, I have my guardianship letter in my phone. My wife has it in her purse. But anything that an adult can do, you have to, and once they turn 18, you have to have that letter to keep them from doing things or being with them to make those decisions. Because without that letter, they're legally able to do anything themselves without you. So that's why the letter is needed, in order to prove to different establishments or whoever that you are the legal guardian of that adult and you're the one that makes decisions for him or her.
And on that point, Boyd, we saw this a lot of with COVID and the restrictions in hospitals, and a lot of our families have kids with, that are in and out of the hospital and what have you. But so whether it's your mother who is incapacitated or is disabled, even with COVID restrictions, you have the right as a parent, as the person with with the disability in those capacities. So even with all of the rules and the hospitals and stuff, you still had rights, but not all of the people that were implementing the rules knew of that. But sometimes they quickly bent once they were aware that you were right. But you do have rights as it relates to that. Let's see, we have another question. This is a good question. I haven't seen this one before. You know how we can have a successor guardian in guardianship? What if the parent that has the supported decision-making dies or is incapacitated? Can there be a successor supported decision-making person?
You have to sign a new document.
Okay, so a new document for that.
Yeah, if you don't have, it doesn't matter who you name in your will. If the child is over the age of 18, then the guardians go away unless you have a guardianship. So.
Okay, so here we have a question, another one, and I know we're just about to wrap up, guys. In a situation where a child has an IQ of 69, who would be described as highly functioning, who is also a child of divorced parents, can one parent get guardianship without having the other parent involved? We get this question every time. It's a great question. And in agreement. So basically, if we have an opposing parent in a divorce situation, what happens, Boyd?
Okay, two situations. Three situations. One where you send a waiver to the other parent and he agrees, he or she. The third situation is that all I have to do is have that other parent served the waiver by a constable, whether he or she agrees to it. I don't care, as long as it's served by the constable, then the other parent can get guardianship. And the third situation is we serve that parent with a waiver, and then the parent comes back and contests the guardianship. I've had two situations recently where we had to go to a hearing. I'm not a litigator, so what happens when I have a guardianship that's contested, I will first tell the parents ahead of time if it's contested guardianship. I don't litigate, and I have a number of attorneys I call to help during the litigation. The other situation I had where a parent contested the guardianship, she was afraid that she wouldn't see her son after the biological parent got it. Well, what I ended up doing is giving her attorney a list of code, estate code, and the rights of the ward. And as the ward can see his biological parent anytime he or she wants to, as long as they're not in any danger. So, and the ward has the right to make that decision, even though dad has guardianship of the ward. So I was able to get that mother to agree to guardianship at the hearing based on what I gave her, that she would have a right to see her son as long as she did not put her son in any kind of danger. So, that goes back to our original question, is that these wards have rights to see friends or see family members if they're not put in any type of danger. So those are the scenarios if you have a one parent wanting the guardianship and the other not. And the same thing with grandparents. They can, if their children are not looking after their grandchildren, then they can file for guardianship, noting that their child are in danger, their grandchildren are in danger or not being taken care of.
So I think, I think that the concern is in a divorce situation, can one spouse use guardianship to shut the other spouse out? So what you're saying is the ward still has rights. However, in the example that guardianship was needed in the first place, that ward may not have they may not speak. They may not communicate. There may be other challenges. So is there a such thing in the divorce world? And I know that you said, both parents could be, co-guardians. So in an example, in a divorce, and one parent is filing for guardianship, could the other parent say, hey, I'm not, balking at guardianship, it needs to happen, but I would like to be co-guardian? And is that an amicable way to work that out, or have you seen that?
Yeah, I've got a couple of divorcees that are co-guardians. They work very well. But one thing you have to realize is that a lot of times these kids get used to a surrounding. And even in divorces with kids with special needs, the normal Wednesday and every other weekend, really, they look at that, because taking some of these special needs kids out of one home and throw them into another one, it just doesn't work sometimes. So I will say that the judges will look at that very closely, especially in a contested guardianship. If we have to bring in the divorce, if there was domestic abuse, then the judge will look at that and really weigh heavily on that. So they really look at it's like the DWI I mentioned before, they really look at the best interest of the children. And at the end of the day, the judge is going to agree to guardianship on whoever's best for the child. So it's not one of these divorces where you take and choose. The judge is going to look after the child first. So
For sure.
I'm really pleased with all the courts around
That's
here.
good. That is really, really good. Well, as usual, Boyd, you did an awesome job, and thank you for being with us. I've heard these guardianship presentations a million times, and it's never enough. I learn something new every single time. So I appreciate you sharing that with us. Lauren, thank you so much for having us. We've got our contact information up here. If you want to talk to Boyd about your unique situation and kind of talk through what may be best for you, that's probably best. Kind of just, chat with somebody that knows. So feel free to reach out. Lauren, thank you so much for having us. We appreciate it. And we're going to get these recordings out, like I said, later today or tomorrow. So thank you again for having us.
Thank you so much, Allison and Boyd. It was so helpful just to learn a little bit more about the ins and outs. It's pretty complicated.
It's a lot.
Yep.
It's a lot. So glad that we have trusted resources like the two of you.
For sure. Thanks so much. Have a great day, everyone. Bye now.
Bye-bye.